Hey everyone, today we'll be answering all of your estate planning questions that you've been dying to ask, I'm sure. So things like, do I need a will? How best to go about that? Do I need a trust for my child? And with us today to help answer all of these questions is Amanda Plant of Counsel at the Geller Law Group in Washington, D.C. And I'm very excited to have Amanda here today. So welcome, Amanda.
Thank you very much, Alvin. Hello, everybody. I'm Amanda Plant. As Alvin said, I work for the Geller Law Group. We're a small firm, and we have offices in Fairfax and in DC. And we do work in Maryland, Virginia, DC, and North Carolina. So
that's pretty cool. I've been to the Christmas party one time at the Geller Law Group, and so I've met a lot of her colleagues. It's very interesting. So Geller Law Group is an all-female firm. Like I think you have around 20 attorneys and staff combined, I think.
yeah, we have 22, and right now we're all female at the moment.
Nice. That's very exciting. So, and I think Rebecca, the founder or the owner, I think her child went to the same school as Shauna, my associate. So her child. So I think they overlapped, and I think they spoke at one time at the school. So it's small world.
Yeah, small world. I think we have something like 30 kids among us at the moment, under 18s. So
oh, wow.
Yeah.
Nice. So thank you so much again for being here, Amanda. And I'm so grateful. I really wanted to do this episode for the longest time. I feel like when I talk with our clients at District Capital, estate planning is relegated to the bottom of the list because there's other more pressing things and this gets pushed aside. But I really understand the importance of it, speaking from personal experience. Like when my dad passed away back in college, my parents didn't have any will or anything like that. So my sisters had to do all the logistics and figure out all that kind of stuff. So, and I know they had a hard time with it. So I know it's very important. So I'm so grateful to have you here, Amanda.
Thank you for having me.
And we are conducting this discussion live. So if you are listening, you can feel free to just type in your questions and we'll do our best to answer them. So I guess my first question to you, Amanda. So obviously we're in this pandemic. Over 100,000 people have already died just in this country alone. And personally, I know a friend of a friend, a couple of them, they've passed away due to the coronavirus. So in this time of pandemic, how important do you think is it for people to have a will in place?
I mean, I think not just a will in place, but a lot of people are coming to us now for things like advanced medical directives, which are, what you want, kind of healthcare decisions you want made if something were to happen to you, as well as a will in place. People realize they don't have anything and now they need it and they're kind of scrambling. So you never want to wait to the last minute to get anything in place, really. But yeah, I mean, it's unfortunate. I know a lot of people have been hit hard. We've had clients, pass away, as well as clients who've had COVID. And I have, some associates and that type of thing who I know have, suffered from it or had family members suffer from it. But yeah, I mean, I guess it's going to show people that it's better to have it in place previously so that you have it in place now. You don't have to worry about it rather than scrambling and trying to get it done now.
Right.
But yeah, I mean, if you have an advanced medical directive in place, then it controls what your medical decisions are and who's going to make those medical decisions for you, as well as, if you become sick and you're hospitalized on a ventilator, that type of thing, a power of attorney is great. So someone can take care of your financial needs or your day-to-day needs, if you're not able to do it for a couple of weeks or whatever it is. And then if, the worst case scenario happens and you do pass away, you want to have some type of, document in place, such as a will or a trust or that sort of thing, so that you get to say what happens to your assets, if you do happen to pass away.
Right. And I think I'm going to go a little bit deeper into that in terms of what you mentioned there, because I think in general, estate planning documents comes with this whole package, right? Like, as you mentioned, advanced medical directive, power attorney, and we'll dive into that more in a little bit. But just in general, if because when I talk to this about people, they say, oh, this automatically, the state will assign who my assets will go to, like my spouse and stuff. So like if someone dies without a will, what typically happens, and is that a problem?
It can be it can be a problem. So you're right that if you die without a will, the state statute assigns who's going to get your assets. But it's not as simple as what people think. A lot of people think, oh, that's going to be my spouse, or oh, that's going to be my children, and that's not necessarily true. I think DC is probably a good example of that. I'm married. I have a 5-year-old, and he's my husband and I's child. He's not a child from a previous relationship or anything. If I passed away and I didn't have a will in place, my 5-year-old would get 1/3 of my assets instead of them all going to my husband.
1/3 of their assets, okay.
Yeah. Which would just significantly complicate matters, as he can't inherit assets directly because he's a child. The court would see it as my husband can't manage his assets because he has a conflict of interest. So they would appoint somebody else to oversee my husband managing our child's assets until he's 21 years old. So that's one example. It's not true in every state. In Virginia, the scenario would be it would all go to my husband, unless we had children from a previous relationship. DC also sometimes give assets to parents. If there's your spouses and you don't have kids, your parents will get some. And that is particularly for like a 5-year-old. I don't want my 5-year-old inheriting anything. I want my husband to get everything.
Right.
And you can take care of that by simply having, a will in place and making sure beneficiary designations are updated on things like, life insurance and retirement accounts and that type of thing.
Right. Wait, did you mention your husband can be seen as a person that has a conflict of interest if he helps? Okay. That is odd. All right. And you mentioned earlier, was that in which state did you mention when you said 1/3 of the assets will go to your child? Is that's
Washington, DC.
Washington, DC. And then where does the other 2/3 go to in DC?
Oh, if you're married, they go to your spouse.
Okay, 2/3 go to your spouse. Okay. Got it.
And then it's different. If you have children from a previous relationship, it's a different cut.
Okay. And it's going to be different in each state, right?
It's going to vary by state. That's correct.
Okay. And so let's talk about that. The 2 or 3 things that you mentioned that goes together with estate planning documents in addition to a will. So advanced medical directive. My understanding is that one is you assign someone to help make medical decisions for you. Is that pretty much what the advanced medical directive is? So tell us a little bit more about that.
Yeah, so it goes by different names that you may be more familiar with. Sometimes people call it a living will. Sometimes call it a healthcare power of attorney. We call it an advanced medical directive, and it kind of serves 2 functions. Some people will have sometimes 2 documents. One assigns who the medical agent is, and the other one assigns like what your wishes are. We do it in one to try to take away the need for 2 documents. But you're correct. So the advanced medical directive will name somebody to make medical decisions for you in the event you're incapacitated in some manner. And then the secondary purpose is it provides guidance as to what treatment you want under certain circumstances. So if you want to be kept on life support or do not want to be kept on life support, or you're an organ donor, or you want to be cremated, or you want to be buried, those would all be included in an advanced medical directive.
So how does the hospital know if, let's say I have an advanced medical directive and I'm rushed into the hospital and I'm unconscious, how do they know that I actually have an existing directive?
Yeah, they probably don't in that scenario. Of course, if you're going in for elective surgery, if you have a doctor you see all the time, you want to have them have one on file. But what we do is, we prepare the document and we give you sample fiduciary letters. And fiduciaries are the people you name to act on your behalf.
Okay.
And those letters explain what that person's, job or role would be. And we encourage you to give them a copy of your advanced medical directive to your medical agent. Because a lot of times what would happen is, say you're in a car accident, they rush you to the hospital, they probably don't even know who you are. They're going to stabilize you. And then once that emergency is over, then they're going to try to figure out who you are, make some phone calls. And that's usually when the advanced medical directive surfaces. And that's when, it's determined what your next treatment is or who is making those decisions for you.
Got it. And when you mentioned someone who I can give, let's say I assign my sister, like I've assigned my third sister. I have 5 sisters. I assigned my third sister to make medical decisions for me. She's a doctor, so I figured she would know better. So I gave her a copy. But so what happens if, and I guess this applies to a will, like typically for a will, you have an executor who will execute the will. So what happens if the executor is no longer around? So who will execute the will?
Yeah, I mean, we encourage people to name at least one alternate. You can name as many alternates as you want.
Okay.
But what would typically happen is if, nobody's available, then there's kind of a priority set out by statute. It's usually like, a spouse, an adult child, your parents, other family members can open the estate. And the first thing they're asked is if there's a will in place, if they've searched for a will. So there's kind of a requirement that they look for a will. And then that's kind of how they're appointed from there. So if the will says that, you're appointing 2 of your sisters, they're not around, nobody else is named, then the court would appoint somebody, and it's usually by priority. They would go to your other sisters first if they wanted to serve.
Okay. And I know in Maryland, I can give a copy of my will to, I can't remember what the name of the department is, but I don't think it's present in other states, that kind of department. Is that standard practice? You share a copy of your will to the government, like order of wills or something?
No, most states it's not available.
No, okay.
I know Virginia does have it in some of the counties, but it's not a great system. They don't really search it if you do file a will. I know we keep wills on file. We have everybody sign it in triplicate, so there's 3 originals hanging around. And hopefully, I mean, there is a little bit of luck. I mean, there's always a chance something's lost and it's never found. But you want to tell your executors, you want to tell everybody this is where your assets are. Keep it somewhere safe. Have the attorney's name on file so they can provide a copy if someone can't find it. So those are kind of the things we try to go over with people to make sure that you want it out there. You want people to know you have this in place.
Right. So that reminds me, you mentioned files.
Yeah.
So I just finished watching season 2 of Dead to Me. It's a Netflix series. Have you had a chance to watch that show?
I haven't.
It's really interesting. I don't want to share any spoilers, but at some point the main character, Jen, pulled out an emergency binder that I guess contains a whole bunch of important documents. So do you typically recommend that for clients, and what would it contain, this emergency binder?
Yeah, absolutely. I mean, we tell people you should keep your will and your other documents, the originals, wherever you keep important documents in your house, and let people know. So we encourage them to give copies, copies to their executor, their trustee, their power of attorney, whomever it is. And those copies can be electronic. They can be just regular hard copies, whatever it is. But for the originals, you want to keep those somewhere safe in a binder or something like that. We also keep, an original in our office or in storage, depending on how long it's been since. And yeah, I mean, you can also, because we give you 2 originals of everything and we keep the third, we suggest whoever you've named as your primary, send them that original so they have it on hand too.
Okay. And then is it just better to... So as the law firm that executed the will, the law firm will have a copy. Is that right?
Yeah, I mean, it's never guaranteed because you never know if a law firm will still be around when you pass away. But we keep a copy, and we actually have people sign something that says that we have permission to give it to your beneficiaries or your executor if you do pass away and someone's searching for it.
Okay. So I know in movies, when someone dies, like there's always an episode where the lawyer comes in, the lawyer meets with the beneficiary. So do you guys do that too? Are you typically in that situation?
I mean, we do. If we have a client who passes away, we are, happy to meet with, whomever they've named if they want to have a meeting with us to talk about it. And we kind of usually go over, explain the documents, that type of thing. And we usually don't charge for that. It's just a kind of a courtesy that we do. If they want us to continue and assist as an attorney on the matter for a probate or something like that, then we can sign an agreement. But that's usually, we kind of walk them through the process and they decide if it's, something they want assistance with or, they want to do it on their own. And we do it with documents we haven't written. People come to us and, or they don't even have a will and they, a probate has to be open and we can serve in that role too.
Right. So I try to implement the advice that I give with clients. So I tell them to have a will. So I've had a will in place for about 10 years now, but I only used an online template. So I filled it up to the best of my abilities, who can inherit my money. And I had my 2 former coworkers that time serve as a witness. And so these online free will templates, what are your thoughts about that? Because I know a lot of people hesitate paying like $3,000 to have a will and all those estate planning documents in order.
Yeah, I don't recommend them. I mean, I think they're probably better than nothing most of the time. Sometimes they're not. We've had a lot of probates, particularly where people have done the online documents and they've done them incorrectly. Maybe they didn't have the correct amount of witnesses. Maybe it mentions a law that was already changed and wasn't valid anymore because those aren't updated, regularly. Or they just made a mistake. They didn't realize who they were giving their assets to. I've seen that with married couples where they wrote the will and they weren't even thinking about it. And they ended up giving assets directly to their kids instead of their spouse.
Oh, okay.
That's usually the mistakes I see with those online services. And, it's going to save you a lot of money on the back end if you do it with an attorney for the most part. Because, you do it online, maybe it's free, maybe you pay a few $100s, depending on what service you use.
Yeah.
But then, I've seen probates where easily the probate fees are 10 grand, 20 grand for a relatively modest estate, something under $100,000 where they're paying that much in probate fees because of arguments or disagreements, or we don't think this will is valid because of this, that, and the other. Or just confusion where it's going to a minor and they have to set up a trust or a custodial account and there's ongoing accountings and that type of thing.
So tell us a little bit more about this probate process. So let's say someone has a will that still goes through the courts, right? And so what exactly happens? How long does it typically take? And can you tell us a little bit more about that probate process?
Sure. When somebody passes away, if they just have a will or they don't have anything in place, then some of their assets will go through probate. The assets that are going to go through probate are ones that do not have a beneficiary designation or don't pass to someone, automatically by the right of law. So like your life insurance, if you have a beneficiary listed and that beneficiary is still living, it would go directly to them. It wouldn't go through probate.
Okay.
And that's the same for basically any accounts. But if you don't have a beneficiary listed, then it's going to go through probate, or if it's a car, or most typically like real property, like a house or something like that.
Right.
That's where it gets a little bit more complex. So your executor would go down to the courthouse, they'd file your will, they'd open up a probate proceeding. Okay. And at that point, they would have to put out, it's all public. You can go down to the courthouse and read anybody's will. They would have to put out notice, and there's a time period, there's a waiting time period for creditors to file claims and, that sort of thing. Once that happens, they would, they have to open up a bank account for the estate. They have to file taxes for the estate, file taxes for you. They have to then gather all the assets, pay off whatever debts there are, and then they can make the distributions based on the will. Okay. So that's pretty much what it is. A lot of times a will can be enough for somebody. It really just depends on what their, specific circumstances are. If you're giving all of your assets to adults, then you can probably get away with a will without a problem. Right. You have the will just to catch anything else. I tell people, update your beneficiary designations. If you own real property, there's a couple of options there. We can do transfer on death deeds, which means it transfers directly to somebody outside of probate. So that's an option if you're giving it to an adult and there's not going to be minors involved.
That's for real estate, you mean?
Yeah, for real estate.
Okay.
For land, houses, that type of thing.
Okay.
The transfer on death deed is available. They don't have one in Maryland, but both Virginia and DC do have transfer on death deeds.
Okay. And I think for bank accounts, you can also have that in place, right?
Yep, most bank accounts you can. It would be a beneficiary, or it would be something called a TOD or a POD, which is transfer on death or payable on death. And that's the same for like investment accounts, brokerage accounts, those kind of things.
Got it. So related to that, and you mentioned this earlier in terms of if the beneficiary is a minor, my understanding is a minor cannot legally hold assets. So sometimes a trust is created either before the will or as part of the will. So tell us a little bit more about trusts. When do you need them?
Yeah, I mean, I always recommend some type of trust if there's going to be a minor beneficiary involved. Because what you said, they can't inherit property directly. You don't want the court involved for, 15 years, micromanaging the estate. And there's a couple of different trusts. There's something called, which is probably the more common one, which is a revocable trust. It's a trust you set up. You're the trustee of it. Assets that are in it, they're your assets. They're not treated any differently. The main thing happens when you pass away. That's when a successor trustee who you name would then gather the assets and start managing them for your, child, for their care, education, maintenance, support until they're an adult or older. A lot of people don't want their kids to inherit, a large chunk of money at 18. So it's more commonly, ages 25, 30, that type of thing. So that's usually what happens with a revocable trust. Everything's there. Nothing goes through probate.
Okay.
Or if anything does, you have a will in place and it shoots it over to the trust. So it's a, very minimal probate. Your trustee manages it for you. Another type of trust, which is more common if people don't have a lot of assets or don't have real property, or there's just a slight chance a grandchild or something will inherit. We do something called a testamentary trust. And that's a trust that's written inside your will. And it just says, if, I pass away and there's a minor beneficiary, a trust will be formed at that time and managed for the beneficiary till they're 25. It's not as advantageous as a revocable trust because there's a big time lag between the assets. They have to go through probate first before going to the trust. But if there's only a small chance that it's going to be a minor, or, again, real property is the big one. If there's not any real property involved, it's not a bad option for people who don't want to go with a full revocable trust.
Got it. So you have a revocable trust, which you create sooner, and you put, I guess you transfer some of the assets there, like your house and maybe even bank accounts. What kind of assets does it typically get transferred to?
Definitely real property.
Okay.
A lot of times business ownership will be transferred to. If you can. I mean, it all depends on the circumstances. It'll be transferred over there, as well as if you want to, you can retitle bank accounts and investment accounts and all of those things in the trust. A lot of people that are younger and still, managing all their assets, just leave it in their own name and put the trust as a beneficiary. That's what happens.
Okay, put the trust as a beneficiary.
Yeah. And that's for you can do that with her life insurance, retirement accounts.
I see.
Pretty much anything.
So essentially the trust can have zero assets in them and then you just designate the beneficiary. It still skips probate, right? Okay. Got it. Okay. So now you mentioned small business owners. So here at District Capital, we do have a couple of clients who are small business owners, like dentists, photographers. We have a YouTuber. So is there anything special that they need to be thinking about when they think about their will or estate planning in general?
Yeah, I mean, it really depends on a few factors, like if they have a partner, for one, as well as if they have an operating agreement in place. But you kind of want to make sure that your business is going to pass in some manner that doesn't involve, probate or an extensive probate procedure. And you can do it a couple of ways. You can do it by assigning your interest to your trust. You can also do it through an operating agreement where you already set out how your business interest is going to pass if you were to pass away. Okay. Both of those options are perfectly fine, and both of them are able to avoid probate, which is usually the goal.
Okay, have an operating agreement or assign
Mhm.
the ownership to the trust. Okay, got it.
And we do all that at Geller. We help people with all of that, all of that stuff. So,
Good. Do you have several small business owner clients?
oh yeah.
Okay,
LLCs are pretty commonplace, I think. I
got
think
it.
they're easy to set up, and everyone, is like, oh, I'm going to sell some things on the side. I'll set up an LLC.
And I know you help, in addition to estate planning, you and Geller also help small business owners in terms of operating agreement and that kind of stuff, right?
Yeah. Absolutely. I do the vast majority of the overlap between estate planning and business.
Mhm.
And then we also have a fairly large business group where people only do business stuff.
Mhm.
I mean, I can help with that too. I just usually don't have the bandwidth to do more business things. But yeah, we can do operating agreements, employment agreements, um, client agreements, waivers, terms and conditions for contract review, all of that stuff.
So one of my good friends told me to ask you this. So he, I believe, inherited some assets recently through a will and the trust. And some of the money is in annuities, some of them are in different types of accounts. So is there anything he needs to be thinking about to like acquire or like deal with those types of assets that he's inheriting typically?
Um, it, I mean, it really just depends. I mean, with the will, I'm assuming your friend's an adult.
Mhm.
So there's not there's not an issue there.
Yeah.
I mean, with the will, he should be getting those assets direct to him.
Uh-huh.
So then he would want to probably speak with you, particularly with like an annuity and stuff like
Right.
that. And we could always help out in those type of situations by reading the annuity contract and seeing what it says happens.
Right.
With those assets
Mhm.
when they're inherited. As far as anything he's inheriting through a trust, it would depend on the terms of the trust. The
Okay.
trust may say he gets it straight out. The trust may hold it for a longer period of time.
Okay.
So that would be dependent on what the trust says.
Got it. And the trust would specify this is the amount of money or this is the types of purpose where you can withdraw money from, and the trust will probably assign how it's invested and managed typically.
Yeah, I mean, it depends on the trust can specify certain assets are going to be treated differently.
Okay.
They can say somebody's getting $10,000. They can say somebody's getting my shares of this company or, something like that.
Right.
So it just really depends, or they're getting a percentage of the estate. So that'll kind of depend on what the assets are and how the trust is written.
Got it. Now, still on the matter of trusts, we also have another client who has a special needs child. And so is there any special trusts that might be formed as a result of that situation?
Yeah, absolutely. So for special needs, they're called just special needs trusts.
Mhm.
There's a few different types. With what you said with a special needs child, what we would do is usually talk to the client about what the special needs are. Is the child receiving, or will they likely receive government benefits in the future? Kind of assess what's needed in that circumstance. If it is something that's probably going to be ongoing and they're going to receive government benefits in the future, we would set up what's called a third party special needs trust.
Okay.
And you can do it one of two ways. You can set it up standalone, where it's just its own trust, handling it, or you can do it as a sub trust under your revocable trust, so it gets created and funded, after you pass away, just through your trust, outside of probate, just through the trust process. And what a special needs trust does is it allows you to give a gift. If it's an older individual, or it's a situation where they're inheriting assets and a special needs trust wasn't set up, you can do a first party special needs trust.
Okay.
Where they're essentially creating it for themselves. Of course, they're probably not. It's probably someone creating it for them, but it's their assets. And that's a way to protect the assets. Those are a little bit more complicated, simply because there's payback provisions required sometimes under them. It depends on the age of the person. But there are ways to protect the assets and protect benefits, even if they do happen to inherit or, come into some money.
Got it. So we're coming to a close, Amanda. I wanted to make sure I ask you. I'm just curious. I'm not sure if I ever asked you this. So how did you personally get into this field of estate planning and wills and stuff?
That's a good one. Well, I mean, I took, wills, trusts, and estates in law school, of course. I thought it was a very interesting course. Some other lawyers may scoff at that. Other people may scoff at that. But I just, I found it very interesting that you could really control things, not during your lifetime, but also, after your lifetime as to how things would be processed and that sort of thing. And I did work with a, small, like solo kind of jack of all trades attorney, and did a couple of wills and stuff with him. And I just got really interested in, as well as, figuring out like the probate process and that type of thing. And I really like helping people. And I know people think, wills, trusts, and estates is a downer. And yet sometimes it is people who are coming to us and they're coming to us, they need an emergency, they need a will right now because they're, getting ready to pass away, or there's a situation with capacity or that type of thing. But a lot of times I'm dealing with people who are young, in their, 30s and have children. And it's not a downer. It's like, okay, let's make these plans in place so you don't have to think about it later. And let's have, the accidents happen. You always want to have it in place just because. And it's better to do it now while you have capacity, because, it's like you're getting on in years or whatever. You're like, oh, I'll get that. And all of a sudden you don't have capacity and you can't get it. And the court's just appointing someone to handle your affairs rather than you kids, or you just got married, or you're just starting your career. You're getting your life insurance. You're, buying a house, or, whatever it is. Just take care of it now. And then you're done. You don't have to worry about it. Or like I said, with a power of attorney or advanced medical directive, what if you're in an accident and you're, out of commission for a week or a month or something like that? If you have those documents in place, that takes care of it. It's not just for after you pass away.
So it's for peace of mind, and also just being able to be more in control about your life, right? So, well, thank you so much, Amanda, for being here and sharing your wisdom with us. I really appreciate it.
Oh, thank you for having me again.
And thanks so much again, everyone, for tuning in. We'll do this again in a couple of weeks at June 27 at 11 a.m. Eastern. That's going to be 3 Saturdays from now. We'll feature another guest, Ian Lay from Long & Foster. Will be talking about house buying tips. So if you're looking to buy property anytime, the DMV area, so make sure you tune in on that. So until then, thank you so much again, everyone. Amanda, take care.
Bye.
Bye.